City of Detroit versus Bernard Brandon Little. Case number SP 1513015, counts 1, 2, and 3. SP 151302991. Appearance, please.
Yes,
Sherika Harris on behalf of Mr. Little. For purposes of arraignment, my client stands mute.
No, I don't.
You don't?
No, sir. I've got a payment plan derived from your department.
Turn your camera on, please, sir, first of all.
Okay. I just hit it.
Do you want representation by this very good lawyer?
From the opening seconds, you can tell this isn't going to be ordinary. The judge is calm, the courtroom is routine, but the defendant arrives armed with confidence instead of comprehension. This is the classic sovereign citizen entrance, half prepared, fully convinced, and completely disconnected from how the legal system works. He believes simply showing paperwork equals immunity. What he doesn't realize is that court isn't a customer service desk. It's a legal process. The judge sets the tone early, offering structure, patience, and an opportunity to proceed correctly. Unfortunately, that offer is about to be ignored. What we're witnessing here isn't oppression or injustice. It's someone mistaking YouTube legal myths for actual law, and the gap between belief and reality is about to get very uncomfortable.
Go ahead. What do you got going on, Mr. Little? What do you want to tell me?
What I'm saying is I got on a payment plan to pay these tickets. I got the payment thing right here in my hand.
Okay, you Pam, you still got to do this no ops.
What's the no ops?
Without a valid license.
Say that again.
Operating a motor vehicle without a valid license.
Do I not have the right to travel?
The moment representation is offered, the familiar distrust appears. The defendant insists the lawyer works for the state, as if that alone invalidates the entire profession. This is where sovereign ideology really shows its weakness, confusing funding with allegiance. Public defenders exist to protect rights, not violate them. The court isn't forcing help, it's offering it. But pride steps in, logic steps out, and suddenly every institution becomes an enemy. Instead of focusing on the charges, the defendant fixates on imagined conspiracies. Courts don't operate on suspicion or vibes. They operate on law, procedure, and evidence. Rejecting legal help here doesn't make him independent. It leaves him exposed, unprotected, and walking directly into consequences he doesn't fully understand.
I could anticipate that argument. All right, so that's not gonna, how do you want to proceed? Because I'm not buying that.
I would like to honor this contract.
I'm not buying that. I'm not buying that.
What you mean you're not buying it? It's your contract. It's your contract.
It's not my contract. Do you want a trial date? Do you want to work the deal out? Take failure to display, $240. Plead guilty.
They got me paying $400. They got me paying $445. That's what they got me paying.
Well, you don't want any help on that, so you want to come with the I have the contract argument, and
no, what I'm saying is this, Your Honor, not to disrupt you. I got on a payment plan because of the tickets. Y'all sent me tickets to my house, right? Okay. They put me on a payment plan to pay the tickets off right here. This is what I have in my hand. It's a schedule stating to pay the tickets off. That's why we're here today, for the tickets, right?
Yes.
Or is it something else? Are y'all trying to get my bonds? There's my bonds here.
So here's the deal, sir. You have 3 civil infractions of improper plate, expired plate, and no insurance, and you have 1 misdemeanor, and that's a no ops. So the misdemeanor is punishable by 93 days in jail, and that's the maximum possible penalty is 93 days in jail and or $500 in fines. This is for purposes of arraignment for Mr. Little. And
Is that a, is that,
Let me
is
finish.
that,
I'll let you finish. Let me finish.
yes, sir. Yes, sir.
All right. And you have, you can pay a civil infraction anytime you want to. That when you pay it, that is admitting responsibility.
This argument has been dismantled in courtrooms thousands of times, yet it keeps resurfacing like it's brand new. Yes, you can travel freely, but operating a motor vehicle is regulated for public safety. The judge doesn't raise his voice, doesn't insult, and doesn't debate ideology. He states the law plainly. Licenses aren't contracts, they're legal requirements. The defendant thinks repeating the phrase louder will somehow transform it into truth. It won't. Courts don't reward repetition or confidence, they respond to statute. At this point, the defendant isn't asserting rights, he's refusing to accept responsibility. And refusal doesn't erase charges, it only delays the inevitable.
Stop, please. I'm not doing anything wrong.
There, you're not letting me finish.
Yes, sir.
The misdemeanors are not something that you can pay. Those need to be adjudicated first, so that's why you had to come to court on those tickets. I see that you entered into a payment plan with those civil infractions. So we're going to strike SP 1513015 counts 1, 2, and 3 from the record, and we'll just proceed with SP 1513029-1. How do you want to proceed? How do you want to proceed on the operating without a license, a vehicle without a license?
I don't believe I have the authority to travel as I need to travel.
All right, I'm denying that. I'm gonna consider that as a motion, and I'm denying that. Okay.
It's no motion. It's a fact. It's a fact.
Well, that's what you argue that. You appeal my decision there.
Here's where things get interesting. The defendant believes paying part of civil infractions somehow resolves everything, including criminal charges. That misunderstanding is massive. Civil tickets and misdemeanors live in different legal worlds. The judge explains this clearly, patiently, and without hostility. Payments don't equal dismissal, and partial compliance doesn't negate criminal accountability. This is the danger of half knowledge. You know just enough to feel confident, but not enough to be correct. The court even removes resolved civil matters from the record, showing fairness. But the misdemeanor remains, and no amount of paperwork waiving changes that fact.
All right, so how do you want to proceed? Do you want to plead guilty today, or do you want me to set a trial date?
I'm not an animal, man.
You're breaking up, sir.
I say animals plead by high like that. I don't plead.
All right, so I'm going to set a trial date. You want a jury trial, or do you want to judge by a trial by a jury, or you want me to hear the case?
If I could not get a fair case regardless, Your Honor, because you're an agent of the state, and as if I get a jury, that the jury will be an agent of the state, because once they register to vote, they become an agent of the state. So how can I get a fair trial in that, Your Honor?
I don't know, but we got to move this case along. Let's get a jury trial date.
Yeah,
I'm not going to spend any more time. There's a lot of people here that want to get their case heard.
Yes, sir. Can I ask you?
The judge lays out potential penalties, explains the process, and gives options. This is due process in action. Nothing rushed, nothing hidden. But instead of engaging, the defendant doubles down on ideology. When the judge treats his claims as motions and denies them, it's not disrespect, it's procedure. Courts don't entertain philosophical debates about sovereignty. They apply law. The defendant's frustration grows because reality refuses to bend to belief. This is where sovereign arguments always collapse, when the system keeps functioning regardless of personal disagreement.
You're an agent of the state, too.
I'll accept that. I was just going to ask the court if the court would consider dismissal based on the fact that he did pay other civil infractions and admit.
He hasn't paid anything yet. He only
Yes,
paid.
I have. Yes, I have. I have paid.
He paid $20. He paid $20. He paid
That's
$20.
that's a part of my agreement. That was a part of my agreement, Your Honor. Not $40, not $60. It was $20. $20 each payment. That's what I did. I didn't give him more than what I agreed to. I gave him what I verbalized and I agreed to, sir.
Very good. Very good.
Fucking double.
Say that again, Say that again, Mr. Little.
Say that again. What?
What comment did you make?
I'm not sure what you want you speaking about.
Speak up now. Say it. Speak up.
I'm not sure which one you're talking about.
Talking under your breath.
I'm talking to another person on the phone. Another phone.
So your next court date, your jury trial date is going to be May 7th. And then we'll set a final pretrial date for the week before that.
Refusing to plead isn't some clever loophole. It's just a refusal to cooperate. The judge doesn't panic or pressure. He simply moves the case forward. That's the power dynamic sovereign citizens misunderstand most. You don't control the court by opting out. The process continues with or without your participation. Choosing a jury trial doesn't magically fix anything either, especially when the reasoning behind it is rooted in conspiracy. The law doesn't collapse because someone refuses to recognize it.